Imagine going in for a surgery that promises to save your sight, only to emerge completely blind in one eye. What went wrong? Who is responsible? A man walks into a clinic with a chance to save his vision. 2 surgeries later, he walks out blind in one eye. Was it negligence or just an unfortunate risk? This is the story of a landmark medical negligence case in Malaysia. My name is Noor Batrisyia binti Kamarudin and my metric number is 2412944. So I would like to address here that the respondent in this case is the patient and the appellants are the doctors, because the case was tried first in the High Court and later was brought appeal to the Court of Appeal by the doctors and later has a last resort by the Federal Court. So here this is the brief facts and the timeline of the facts. For the first one is that having the issue was this dry retinal tear diagnosis, where the respondent was diagnosed by the Dr. Hari, like he has having a dry retinal tear and was recommended to have a operation. So the operation was without any imaging scans or without any diagnosis has to be done. However, it's the standard medical practices during that time. So the operation was performed at Tun Hussein On National Eye Hospital. Later, the respondent suffered some continuous pain and pressure in his operated eye. However, he went for the recommendation for the second surgery, but without noticing that he actually has improvement in his vision, but the doctor was asked to have the second surgery. The respondent requested a scan to confirm the condition and asked for the same anesthetic for this first surgery, but he was being refused by the doctors. So, for the fifth one, we can see the second surgery and the complications. It was revealed that he bucked during the surgery, leading to suprachoroidal hemorrhage, and that was suffered to blindness. He suffered a continuous bleeding after the second operation, lead to his blind in one eye. So after going through all the facts, we identify that this involved the standard of care of doctors using Bolin-Bolito and Rogers test. First, we have to identify duty to diagnose using the Bolin-Bolito test. Second, we have to identify duty to treat using the Bolin-Bolito test also. And the third is the different to duty to one using the Rogers test. And fourth, then we identify whether they fulfill and follow standards as a doctor or proven otherwise. And five, we can see whether the application in this case. First thing first, we had to abstract the legal issue regarding all the duties. So first, the duty to diagnose, whether Dr. Hari to perform a scan to confirm the respondent's retina condition before recommending the second operation constitute a breach of his duty to diagnose. And second, duty to treat, whether the surgical procedure including the management of the complications like the suprachoroidal hemorrhage were conducted appropriately and met the standard of care of a competent medical professionals. And the last one, using the Rogers and Whitaker test, duty to warn or advise or disclose the risk. First, whether the respondent provided informed consent based on a clear understanding of the risks and the option available that can lead to the SCH and blindness. To answer the first legal issue regarding whether Dr. Hari failed to perform a scan to confirm the respondent's retina condition before recommending the second operation constitute a breach of his duty to diagnose. Alright, so first, duty of diagnose, adequacy of pre-operative assessment. So during the first operation, where the Dr. Hari's recommendation for the immediate surgery was consistent with the standard medical practice for a giant retinal tear. However, this recommendation having without conducting a comprehensive diagnostic evaluation such as imaging scans to confirm the necessity of the procedure, which later raises question about whether he had fulfilled his duty to accurately diagnose the patient's condition before proceeding with the surgery. So second, we have the duty to treat, whether the surgical procedures, including the management of the complication like the suprachoroidal hemorrhage, were conducted appropriately and met the standard of care of a competent medical professionals. So, duty to treat, appropriateness of the surgical intervention. The decision to perform a second operation without additional diagnostic confirmation, despite the patient's reported improvement in vision, may indicate a deviation from standard medical practice. This brings into question whether Dr. Hari provided treatment that meet the accepted standard of care. So later, we have the post-operative care and management. Following the surgery, the patients experience several complications, including continuous pain, bleeding, and loss of vision. This situation raised concern about the adequacy of the post-operative care and whether Dr. Hari appropriately managed the complications. So the last one is whether the respondent provide informed consent based on the clear understanding of the risks and options that lead to SCH and blindness. So, duty to warn is basically the informed consent, the consent of the respondents. First, disclosure of the risk. Dr. Hari has failed to inform the patient about the significant risks associated with the surgery, such as the possibility of bucking during the procedure leading to the SCH and the potential blindness. So, we knew that a reasonable patient will have considered this risk significant as a lie since it could result in the permanent loss of vision. The lack of the sufficient warnings before both surgeries constitute a breach of the duty to disclose material risks. So meaning that this breach directly impacted the respondent's ability to make an informed decision about undergoing the second surgery. And the second, we have the causation by harm, where the respondent's blindness resulted from SCH, which occurred due to bucking during the surgery, meaning that this harm could have been avoided or mitigated had proper precaution and informed consent been assured.
Thank you to Batrisyia for explaining the details of the case, the vulnerability test, and also the Roger test. Now, I want to arise about the hospital, which is the third defendant, I want to arise two legal issues on this matter. The first one is whether private hospital that contracted with doctors that work as an independent contractors can be held vicariously liable for the sole negligence of doctors. The second legal issue I want to arise is whether the hospital was liable for the negligence of Dr. Hari and Dr. Namazi based on the doctrine of non-delegable duty. So now we're back to the first legal issue, which is whether a private hospital that contracted with doctors that work as an independent contractors can be held vicariously liable for the sole negligence of doctors. So I want to explain briefly what is vicarious liability. Vicarious liability is when A liable to C for damage that's suffered by C due to negligence or other thought committed by B, meaning that A is liable even though the party did not do the thought, but they have a connection by B, which is B do the negligence, B do the thought, but then A is liable to C because he had a connection with B. From the Dr. Hari Krishnan case, they established two elements that must be satisfied, which is the first one is the relationship between defendant 1 and defendant 2 must be one of employment or sufficiently akin to employment, meaning that sufficiently akin to employment doesn't mean about a independent contractor or client, but something that closely to employment. Second, there must be a sufficiently close connection between the relationship and Defendants 1 Torts Act. And from the case of Zul Hasminar, which is they said if there was no thought committed, vicarious liability cannot be attributed. Okay, now we go to the first defendant, which is Dr. Hari. Here, Dr. Hari consulted the plaintiff at his private clinic, which it was a follow-up appointment after the first operation. And then the court cannot find evidences that ensures the hospital exerted any control over Dr. Hari's advices and the conduct of his conduct to the second operation. And the advices that was given from Dr. Hari and also the conduct of the second operation were attributable to his own recognizably independent business, meaning that Dr. Hari is an independent contractor. And then follow up to the Dr. Kok Chung Seng advising the plaintiff on and conducting the second operation. Dr. Hari was indeed acting in the capacity of an independent contractor, and he is not an employee to the hospital. Therefore, vicarious liability cannot be imposed to the hospital based on the first defendants of Dr. Hari. Okay, now we will go to the second defendant, which is Dr. Namazi. On the second operation, Dr. Namazi was on duty for all operations that require general anesthetic. Plus, Dr. Namazi was a visiting consultant on that day. And whatever the work that Dr. Namazi do, the management of the hospital could not interfere in terms of the doses that he used to anesthetic the patient, which is the plaintiff, and all of the things that he already done. And plus, Dr. Namazi, he was not paid by the hospital. His fees were paid by the patient to Dr. Namazi through the hospital. It was the hospital nature to manage all the fees and give it to Dr. Namazi, but doesn't mean that they employed Dr. Namazi. And these factors are more too characteristic of a contract for services with independent. So therefore, there were no vicarious liability that can be imposed on the hospital. Okay, now we were wondering, what about the doctrine of non-delegable duty? Is it can be imposed and prove that the hospital was liable for the breach of duty? So, we go to the second legal issue, which is whether the hospital was liable for the actions of Dr. Hari and Dr. Namazi based on the doctrine of non-delegable duty. Before I go for the explaining, I want to explain briefly is what is non-delegable duty. Under the doctrine of non-delegable duties, there is an existence of personal liability on the defendant based on the defendant's relationship with the plaintiff, meaning that the defendant's relationship with the plaintiff regardless who is performing the task. And then it is in essence a positive duty to ensure that reasonable care is taken and must be pleaded. Now we will go to the features of non-delegable duties, which is there are 5 features. The first element is the claimant must be dependent and vulnerable on the defendant's protection from risk of injury, meaning that the claimant, they are really dependent on what the defendants say about what's their advices or their conducts, because they want to protect themselves from the risk of injury. And the second element is there is an antecedent relationship between the claimant and the defendant, which impute an assumption of responsibility on the defendant to protect the claimant from harm. The third element is the claimant has no control over how the defendant chooses to perform the duty, assumed whether personally or otherwise, meaning that the claimant, they have no control how the defendant want to perform on them, which is, for example, the amount of the anesthetic that will be used to the claimant. They don't know about it. They don't have any idea about it, and they just rely on the duty, they perform the duty assumed, which is they has no control over it. And the fourth element is the defendant has delegated to a third party a function which is an integral part of its positive duty towards the claimant, and also custody and control incidental to that function. And the last element, which is the fifth one, is the third party was negligent in the performance of the very function assumed by the defendant and delegated to him. Now, we want to apply all the elements on the facts of the case that we want to prove that the hospital was liable for the negligence of the 2 doctors based on the non-delegated duty doctrine. Okay. So from the first element, what we could apply is the patient was admitted in the hospital for the second operation, which they fell into the category of especially vulnerable person and was dependent to the hospital for protection, meaning that the defendant really dependent to the hospital because they believe that the hospital will protect him for the risk of injury from the operation. Okay, then the second element, what I could say is that what we could apply is firstly the plaintiff was undoubtedly placed in the hospital's custody or care upon admission for the purposes of the second operation, meaning that the plaintiff he was placed in the hospital because of the second operation, right? So there are a relationship between that because the role of the hospital was confined to provide the necessary facilities and services for the second operation. And the plaintiff also relied on their service, including the anesthetic services. The hospital, how the hospital being the provider? By they are being the provider of anesthetic services through Dr. Namasi. Now we want to apply the third element and the fourth element. So the third element, what we could see here that the plaintiff totally had no control over how the hospital chose to provide anesthetic service for operation that were conducted, because how could the plaintiff possibly see and know about the internal arrangement between the hospital and the anesthetist, which is Dr. Namazi on duty on the day of his operation. And Dr. Namazi's name also not displayed as a visiting consultant on the signboard. Plus, in fact, the plaintiff already asked for Dr. Manavalan, who is the anesthetist on the first operation, but it was informed that Dr. Manavalan was not available at that time. So Dr. Namazi was the only anesthetist on duty on the day of the second operation, and plus he was involved to all operation at the hospital which required general anesthetic. Okay, for the fourth element, yes, Dr. Namazi was responsible to administer doses properly to keep the plaintiff anesthetized, and it was the integral part to the positive duty assumed by the hospital to the plaintiff, which is they need to ensure care is taken in the provision of anesthetic. Meaning that, yes, Dr. Namazi, he is responsible to administer doses properly to keep the plaintiff anesthetized, and it is the responsible of the hospital also, which is they need to ensure the care is taken to the plaintiff. Now we go to the fifth element, which is Dr. Namazi was negligent in the performance of the duty delegated by the hospital to him, because the plaintiff was awake during the operation because of the lack of doses of the anesthetic, and the duty to perform the anesthetic was in fact delegated by the hospital. So, applying to the principles in Woodland, the hospital owed a non-delegable duty to the plaintiff because they satisfy all the fifth elements of the non-delegable duty.
So we have the decision from the High Court, Court of Appeal, and the last Federal Court. So after a full trial at the High Court held that the surgeon and the anesthetic, collectively doctors involved in the procedure, were negligent in the diagnosis and treatment of the patient and in failing to warn the patient of the risk in the operation. And also, the High Court also found that the private hospital where the operation was carried out vigorously liable for the negligence of the doctors. So, meaning here the patient was awarded with 2,000 ringgit as a general damages and the unprecedented sum of 1 million ringgit as aggravated damages. So later, the doctor want to appeal the case, but however, the Court of Appeal dismissed the appeals and by the doctors and the hospital, and they also affirmed the decision and the award of the High Court. So the doctor still dissatisfied with the Court of Appeal decision. So the court of so the doctors and the hospital appeal once again to the federal court on various questions of law. So the federal court unanimously dismissed the doctors and the hospital's appeals and again affirmed the damages of the High Court. Alright, let's take a look at federal court's grounds of judgment. So our case was heard together with Zul Hasmina Hassan case, which later the federal court clarified Malaysian law on a medical negligence, where it emphasized a distinction between diagnosis and the treatment, which courts cannot evaluate as they lack medical expertise, and the duty to advise patients of risk, which courts can assess as a factual issue. So later the court reaffirmed that the Bolam test, as modified by the Bolito, applies to the standard of care in the diagnosis and the treatment. And the second is the Rogers test from Full Fiona, applies to advising patients about risk. And the last one, we knew that the Bolito qualification means expert opinions must withstand logical scrutiny. If expert evidence is deemed illogical or unreasonable, the court can reject it. So what we learned in the I appeal. In this case, the federal court found that the doctor's negligence in diagnosis, treatment, and failing to warn of risk. This decision was based on inconsistency in the expert evidence provided by the doctors, which failed to meet the required standard of the logical analysis.
The federal court's decision in Dr. Hari Krishnan and another against Megat, Noor, Ishak and another has been subject to substantial critique for its impact on medical negligence law, hospital liability and the legal framework for patient care in Malaysia. I want to arise something that I want to say about the doctrine of non-delegable duty of care, which is yes, the court held that a hospital owes a non-delegable duty of care to patients for actions performed by independent contractors, such as the anesthetist in this case, which is Dr. Namazi. While this ensures accountability, it raises also concerns about the extent of hospital liability. Many critics argue that this approach unfairly burdens hospitals with liability for independent professionals' actions, even when the hospital exercises reasonable care in selecting and supervising them. This decision could deter the hospital from contracting with specialists, potentially limiting access to advanced medical care.
The second criticism is that I found regarding the ambiguity in the application of the standards of care. First, the court's reliance on different standards for different aspects of medical practice creates ambiguity. We have three principles: duty to diagnose, duty to treat, and duty to advise or warn. So, for duty to diagnose and the treat, the Bolam test, as qualified by Bolito, was applied, which gives deference to professional opinion if it withstands logical scrutiny. And the third, duty to advise. The Rogers against Whittaker test was applied, emphasizing patient autonomy and the need for disclosure of risk. So, these three standards of care creates practical difficulties for healthcare providers who may struggle to balance professional judgment with patient-centered care in a diverse clinical situation.
What I could say more is about the award of aggravated damages, which yes, the court awarded 1 million ringgit in aggravated damages, a significant sum intended to reflect the gravity of the emotional distress and suffering caused by negligence. While this decision acknowledges the impact on the patient, it sets a precedent for high awards that could, firstly, encourage defensive medicine, where doctors order unnecessary tests and procedures to protect themselves from litigation. By this, it will lead to increased healthcare costs, burdening both hospitals and the patients. Furthermore, the basis for such a high aggravated damages award was not fully articulated. leaving room for judicial discretion that might lack consistency.
Fourth criticism that I found is that the lack of clarity on hospital-doctor relationships. First, the case does not provide a clear framework for understanding the contractual and professional relationships between the hospitals and independent medical practitioners. This case involved private hospital, so hospital might face greater financial and operational risks without clear guidelines on the scope of their liability for contractors' negligence, which mean this could result in changes to how hospitals manage staff's contracts or medical services.
Also, the potential overreach of judicial activism, where some legal commentators have suggested that the decision represents judicial overreach, which the court stepping into policy making territory by imposing significant liability on private hospitals. They also argue that such decisions could have been better handled through legislative reform rather than judicial intervention, because the latter may lack the comprehensive consultation process that accompanies legislative changes.
Last one, we found that the lack of guidance for future cases. The decision has been criticized for failing to establish clear principles for determining the threshold of hospital liability in the future cases. By emphasizing the non-delegable duty doctrine without offering detailed parameters, the judgment risked creating uncertainty and a potential flood of litigation against the hospital.